Good evening aspirants, welcome to daily editorial analysis brought to you by Shankar IAS Academy. Today's date is 22nd February 2025. So these are the two important editorial articles we are going to discuss in this video. The first article is about the court case backlogs. So why is there so much backlogs in Indian judiciary and what are the reasons for it and what can be done to address this huge burden? So this editorial article is taken from Hindu newspaper. The second article is about law weaponized, which is talking about the Special Marriage Act, which has many loopholes, and this article is taken from Indian Express. So these are the two editorial articles we are going to discuss. Now let us get into the discussion. Now look at this article. The article highlights a massive backlog of court cases in India, and the author of the article is suggesting a solution like mediation could be the practical solution for this huge backlog of cases. So this backlog of cases is creating a huge burden on Indian judiciary. So this is what discussed in this news article. In this context, let us discuss about this massive backlog of Indian judiciary and what can be done to reduce this burden. Look at the statistics of backlog of cases in Indian judiciary. The Supreme Court has over 82,000 cases pending before it. High courts have over 62 lakh cases pending all over India. The lower courts have nearly 5 crore cases pending, and around 50 lakh cases have been pending for more than 10 years. So this is how huge the backlog of cases in Indian judiciary. Now what is the reason for huge burden on Indian judicial system? The most important factor is adversarial system. See, India follows adversarial legal system, meaning every case allows multiple appeals, interim applications and procedural hurdles. So this leads to unnecessary delays and complex litigation. The next important reason is low judge to population ratio. So India has only 21 judges per million people, and this is one of the lowest ratios in the world. So we need more judges to handle high number of cases. The next important factor is excessive litigation culture. See, Indians are quick to take disputes to the court. Whether it is a landlord-tenant conflict or business disagreement or family dispute, they are very quick to take the disputes to the court. So this culture overburdens the court with cases that could be resolved outside the legal system. So this excess litigation culture is also an important factor in contributing the huge burden to Indian judiciary. The next important factor is government acting as a major litigant. So government is involved in huge number of disputes that go to court unnecessarily. Many cases involve minor issues that could be resolved through administrative solutions instead of seeking litigation in courts. The next important reason is a lack of infrastructure and resources. See, most of the court lack proper funding and staffing system. They also lack digital systems in order to process the case efficiently. The retired judges are sometimes brought back to handle the cases, but this is only a temporary solution. So this lack of infrastructure and lack of resources also lead to excessive addition of litigation. Now what are the consequences of this judicial delay? Justice delayed is justice denied. As this famous saying, long awaiting periods make the legal victories meaningless. So this leads to denial of justice those who need at time. Then the cases pending for years lose crucial evidence and witness. So this leads to unfair outcomes after some period of time. The judges are also overworked, leading to poor quality decisions. So there is very less number of judges per million population. So this leads to judges being overworked and they lead to poor quality decisions. Next one is increased legal cost. The long cases have become expensive, which affect the common people and small business. So this leads to increased legal cost for litigation and the processing. As we have seen in the editorial article, the author of the article is suggesting mediation as a solution for this huge burden on judiciary. Now what is mediation? See, mediation is a process where a neutral third party helps to solve the disputes either through mutually acceptable solution. So this is either voluntary, confidential and non-adversarial. So this means no one is forced into a decision. So the main aim of the mediation process is to help the both parties to come to an agreement. This is unlike a judge imposing a verdict which is binding on the parties. Here in mediation, both parties come to a mutual agreement. Mediation started gaining recognition in India in 1990s. and formally it was shaped in 2005 as alternate dispute resolution mechanism. It has worked well in civil, commercial, matrimonial and business disputes. Now, what are the important benefits of mediation? The first one is faster resolution. A legal case which may take years to solve in court can be settled in few mediation sessions. So this saves the judicial time and also helps to resolve the dispute quickly. The next one is they are cost effective. See, the litigation process is expensive, which means the mediation is much cheaper. So there is no need for huge legal fees or lengthy court procedures. The next important benefit is confidential and private. Court cases are public records, which means they are disclosed to public, while mediation remains private and confidential. So this helps business and families to resolve their disputes discreetly. Mediation also focuses on mutual agreement rather than a legal fight. So this helps families, businesses to maintain better relationship even after resolving the dispute. Most importantly, this mediation will help reduce the burden on the courts. If more cases are resolved through mediation, then the courts can focus on serious criminal and constitutional matters instead of civil disputes. So these are some of the important benefits of mediation. And this is an important mains question regarding this topic. Interested aspirants can try to answer it and post the answer in comment section. With this, let us wind up this discussion and move to the next news article. Now look at this article. The article discusses there is a no objection provision in Special Marriage Act and how this provision undermines the purpose of this Special Marriage Act. So there is a case where a Hindu-Muslim couple in Bhopal faced violence after registering their intent to marry. So this no objection provision means according to this Special Marriage Act, there is a public notice requirement. So this public notice requirement compromise the individual rights and they enable moral policing. So this Hindu-Muslim couple in Bhopal faced violence after registering their intent to marry. This is because of this public notice requirement which is mentioned in the Special Marriage Act. Now, why is this provision being disputed in Special Marriage Act and what are the basics of this act? So this is what we are going to discuss in this article discussion. Now first let us discuss the basics of Special Marriage Act which is enacted in 1954. The objective of the act is to legally recognize the interfaith and intercaste marriages. It also ensures the compliance with Indian laws. The aim of this act is to provide a secular alternative to personal laws which govern the marriage and divorce. Now looking at the key provisions, there is an important provision called public notice requirement. According to this public notice requirement, the couples who are going to marry must give a 30-day public notice at marriage registrar's office. So any individual can object based on the legal grounds. After 30 days, if no valid objections are received, the marriage can be conducted. So this public notice requirement clause is now being used against the interfaith couples. So this also go against the privacy and the safety of those couples. Now according to this Special Marriage Act, the age requirement for the couple should be, the male should be 21 years, the female should be 18 years and both parties must be mentally sound and capable of giving consent. Neither party should have a living spouse at the time of the marriage. So these are the requirements under the Special Marriage Act. Now let us see some constitutional provisions related to marriage and privacy. Article 21 which deals with the right to life and personal liberty. This article recognizes the right of a person to marry another person of his choice. Article 14 which talks about the right to equality. It prevents discrimination in the matters of marriage. Article 25, it deals with the person or allowing the individuals to practice and propagate their faith and supporting the interfaith marriages. So these articles are important regarding the marriage and privacy. Now comparing with the Hindu and Muslim personal laws. Hindu Marriage Act of 1955. This act specifies conditions under which the marriage is considered void or voidable. So this act primarily focuses on relationship between the spouses. The Supreme Court of India observed that a relief against third parties cannot be claimed in proceedings between the husband and wife under this Hindu Marriage Act. If you look at the Muslim personal laws, they derived from religious texts and customs, and they emphasize the autonomy of marital relationship. All India Muslim Personal Law Board has stated that the personal laws are based on religious scriptures and customs, and the court should not interfere in them. So this is regarding the Muslim personal laws. Now let us see some important judgments regarding the marriages and divorce. Justice K.S. Puttaswamy vs. Union of India case in 2017. This case recognized the right to privacy as fundamental right under Article 21. It also stated that personal autonomy in marriage, relationship and identity is considered as fundamental aspect of privacy. This case also strengthened the legal arguments against the state or social interference in personal choices. The next important case law is Shafin Jahan vs. Ashokan KM. So this is in 2018. In this case, the Supreme Court upheld an adult woman's right to marry a person of her choice. So this case judgment reaffirmed that marriage falls under the right to personal liberty and privacy. The next important case law is Lata Singh vs. State of Uttar Pradesh in 2006. In this case, Supreme Court ruled that adult woman has a right to marry anyone of her choice. In this case, the Supreme Court also warned against honor killings and harassment by families. So there are many legal gaps in the protection for interfaith couples. Unlike Hindu and Muslim personal laws, the Special Marriage Act lacks adequate safeguards against the forced interference from third parties. So the absence of stronger legal protection for interfaith couples is leading to judicial dependency on the relief. So what can be the reforms done to address these challenges? The most important one is to amend the Special Marriage Act to remove the public notice requirement. So as we have discussed earlier, the Special Marriage Act requires the interfaith couples to register their marriage before 30 days of marriage. So this is called the public notice requirement clause, which we have discussed earlier, and we have to amend this Special Marriage Act to remove this public notice requirement. So the Law Commission and Supreme Court have suggested removing this clause. We should also strengthen the legal protection for interfaith couple. So implementing a fast-track grievance redressal mechanism for the victims of harassment can be a good choice. Also ensuring the police protection and dedicated support cells at district level. The Supreme Court should examine the state laws on interfaith marriage in order to check the compliance with the constitutional rights. It should also ensure religious conversion laws do not infringe upon the personal freedom. Then there should be clear guidelines for marriage registration. So issuing standardized rules for marriage officers in order to prevent the arbitrary objections or delays. Also simplifying the documentation process for the interfaith marriage can be a good choice. So these are some of the reforms that can be done to safeguard the interfaith couples. So in this discussion, we have seen the basics of Special Marriage Act and its comparison with the Hindu marriage laws and Muslim marriage laws, and what are the constitutional provisions regarding the privacy and marriage, and what are the challenges for interfaith couples in interfaith marriage, and what the reforms can be done in order to safeguard the interfaith marriage. So with this, let us conclude the discussion. With this, we have come to the end of the discussion. If you like the video, please share it with your friends and don't forget to subscribe to Shankar IAS Academy YouTube channel. Thank you for watching.